Good evening and welcome to League of Women Voters Presents. I'm Jim Robertson, and our topic tonight is voter ID, more specifically photo ID for voters. It's Amendment 6 on the November ballot, and you'll be hearing more about it. My guest tonight is Denise Lieberman, and she is with the Advancement Project, which is a national organization concerned with voter rights, particularly minorities. And Denise is an adjunct professor at Washington University in St. Louis. She is nationally known for her work in voter rights. And fortunately, she lives right here in Missouri and has been engaged in the debate and the movement over this constitutional question. Thanks for being here tonight, Denise. You had a little tough trip, I understand, but you're here now.
I am. Thank you for having me.
Good. I'd like to start with a little history behind this movement for photo ID for voters. It's not a new concept in Missouri, and in fact, it was turned down once by the courts, right?
That's right. And in many ways, Missouri has been a poster child for the photo ID debate nationwide. We were one of the first states to pass a strict photo ID law back in 2005, and that law was found to be unconstitutional by the Missouri Supreme Court, which found that it violated our state constitution's protections that guarantee free and equal access to the right to vote.
Mm-hmm. And actually, we do have to have an ID to vote in Missouri.
We do, and a lot of people don't realize the Missouri law already requires all voters to show an identification at the polls. But the forms of identification voters can show are varied enough that most voters are going to have those forms of ID. The proposals that have been before the legislature and that will be before the legislature again would severely limit the kinds of ID that voters could show at the polls.
And tell us a little bit about the history of the legislative effort to get this done.
Sure. Well, like I said, Missouri was one of the first states in the country to pass a strict photo ID law. And back then, people thought that those laws maybe made sense, that they were necessary to prevent voter fraud. But over the last 10 years, the evidence has become overwhelming that in fact they don't do anything to advance the integrity of the elections, that incidents of in-person voter impersonation just don't happen. They're exceedingly rare, and that many voters don't have or aren't going to be able to get without extreme difficulty one of those limited forms of ID. And here in Missouri, our law works. Both Democrat and Republican secretaries of state have concluded that voter impersonation is something that just doesn't happen in the state of Missouri. Our laws that already require voters to show ID at the polls have done a fine job of upholding the integrity of the elections while also ensuring that all voters are able to cast a ballot.
Why do you think then that, and if this recent polling is to be believed, that 70% of Americans are in favor of voter ID, and photo ID, I suppose. I'm not sure about the methodology of that polling, but why do voters still insist?
And I would suggest to you that here in Missouri, those numbers are smaller. Mm-hmm. Because we've been fighting these fights here in Missouri, only about half of voters in the state think that voter ID and some sort of broad concept is a good idea. But what we know about that polling is that while it may be broad, it's very shallow. And that when voters learn about the specifics of these laws, when voters learn about the ways that people are cut out by these laws, when voters learn how confusing these laws are, and when voters learn how costly these are to taxpayers for no real gain, they change their mind. We saw a measure in Minnesota in 2012, somewhat similar to the measure that will be before voters this November, and that originally polled very high too. And when voters learned how costly and confusing the law was, how much it was going to cut voters out of the process, they defeated that measure resoundingly.
This is kind of, in Missouri this year, is kind of a two-part ballot. I mean, on the ballot is a constitutional amendment that would enable, give the legislature cover, basically, to enact a law that the Supreme Court threw out 11 years ago. Is that characterizing that correctly?
Yeah, and that's one of the ways that this process here in Missouri is very confusing. But at the end of the day, this constitutional amendment, Amendment 6, that will be on the ballot in November, is an end run around our constitutional right to vote in the state of Missouri. We already know that photo ID is unconstitutional in Missouri. The Missouri Supreme Court found that it violated the protections that guarantee Missouri voters the right to vote. Lawmakers ever since have been so intent on implementing restrictive voter ID proposals that they're willing to go so far as to amend those very portions of the Constitution that guarantee our most precious right, the right to vote. And that's exactly what Amendment 6 does. It's an end run around our Constitution. It carves out an exception to the parts of our Constitution that ensure that voters have the right to cast a ballot in this state in order to give the legislature leeway to implement a restrictive voter ID law that's already been found to violate voters' rights.
And by the way, has been vetoed by Governor Jay Nixon.
That's right.
I suppose that will be coming up in the veto session next month.
That's right. The legislature passed a photo ID law this year, House Bill 1631. Governor Nixon vetoed that bill, but that legislation couldn't actually be implemented even if the governor hadn't vetoed it unless we changed the Constitution, and that's what Amendment 6 is all about. We do expect that the measure will likely be up before lawmakers when they return to Jefferson City in September for the veto session, and we're hopeful that they'll sustain the governor's veto. It just makes sense. Governor Nixon, in vetoing this legislation, pointed out that the right to vote is the most fundamental of rights, and that this legislation stood to make it harder for Missourians to cast a ballot. Lawmakers who've taken an oath to protect and defend our state constitution should listen very carefully to the governor's words in that veto letter and uphold that veto.
You mentioned that the folks and voters in Minnesota, when they learned about the expense, that was part of the argument against photo ID. How does that play out in Missouri? What is the expense of implementation?
This legislation is very costly. It's costly here in Missouri. It's costly around the country. The fiscal note for would indicates that this legislation would cost $17 million of taxpayers' dollars to implement. When we are in the midst of a budget crisis, we're cutting essential services to the neediest of Missourians. And lawmakers are putting out a proposal that would cost taxpayers $17 million for a measure that not only would not advance the integrity of our elections, but would actually cut out hundreds of thousands of valid registered voters from the process.
Yeah, I think the Secretary of State estimated, 220,000?
That's right.
Yeah.
220,000 current valid Missouri voters who are voting right now with no problems, who have identification that can get them to the polls, don't have a state-issued photo ID on record with the Department of Motor Vehicles. And an additional 135,000 on top of that have some form of ID, but those IDs are expired and they would have to get them renewed. And the process to getting a state ID or renewing one can be very treacherous for people who don't have access to underlying documents like a certified birth certificate, social security card, marriage license, or whose documents have errors on them that they'd have to correct before they could get a state ID.
Now, does this law not provide for helping those folks get the underlying documents they need in order to get an ID for voting?
Well,
isn't that part of the expense?
The legislation provides that the Secretary of State's office is supposed to assist voters in getting those underlying documents. But as we've seen in court cases around the country, it is extremely difficult to do even when you have help. For some people, they're not going to be able to get them at all. For someone who doesn't have a birth certificate, someone who was born at home, someone who was born to a midwife, someone whose documents were destroyed in the tornadoes in Joplin or hurricanes in Katrina, as we found a number of Missourians don't have those documents. They're simply not going to be able to come up with those documents. And for people who have errors in those documents or whose documents exist out of state, that legislation is going to provide little relief for people who have to go digging through countless bureaucracies in states around the country, go through boxes. Our lead plaintiff in North Carolina, who challenged the North Carolina voter suppression law that included a photo ID requirement similar to Missouri's, had to go to 10 different government offices, expend over 200 miles. This is a 95-year-old woman, solely because the way that her name was spelled on her birth certificate didn't exactly match the way that her name was presented on her Social Security and the way that her name was presented on her voter registration. And for her to reconcile that simple name error required her to go to numerous government offices and change her Social Security. And this is a woman that had been voting successfully for over 70 years in that state. Our plaintiff in Wisconsin, she was born in the segregated South at home to a midwife because her family wasn't welcome at the local hospital. They simply didn't have a birth certificate. Her daughter spent 6 months and quite a bit of money trying to get officials in Tennessee to go through old records from segregated grade schools, looking for some scrap of documentation that documented her birth. And this was a woman that has a current valid driver's license from another state before she moved to Wisconsin. And she was not able to ultimately get those underlying documents necessary.
I'm interested in the cases in North Carolina and Wisconsin. How do those laws differ, or do they differ from what Missouri law could be after November?
Right. Well, the laws that we're seeing around the country, strict photo ID laws, generally require voters to present a current, non-expired, state-issued photo identification that has a photo on it, that has an expiration date, and that expiration date cannot be expired. Many of those states also allow some form of federal identification that's also non-expired, like a United States passport.
So a driver's license would qualify.
Typically, it's a driver's license or a non-driver's license,
Right.
something that you would get at the DMV. And that's really the common core that links these laws across the country, is that this is the kind of ID that you have to get at the DMV, and that's really where the problems come in. And any of us who've renewed or gotten a driver's license at the DMV know that that can be a hassle. But when we attach that to the exercise of a fundamental right, it can become more than just a hassle. It can become a full abridgment of our right to vote.
So let's talk about Texas for a minute. That's somehow different than the North Carolina law, and Wisconsin, as we talked earlier, had just been the action that overturned that has been stayed, or the Wisconsin law is in effect. Temporarily,
right, and it does take an avid court watcher to keep up with all these court decisions. In just the last few weeks, federal courts in states around the country, North Carolina, Wisconsin, Texas, North Dakota as well, struck photo ID laws, at least temporarily, from the ballot for this November. In North Carolina, they threw out the photo ID law altogether. In Wisconsin, a trial judge ruled that the ID law could not be in effect for this coming election. An appeals court this morning temporarily blocked that. We'll see if the broader panel of that appellate court continues to block that or not. In Texas, the Fifth Circuit Court of Appeals ruled that the Texas photo ID law violated the Voting Rights Act, that it had a discriminatory impact on African American and Latino voters. And it sent the case back down to the parties to determine whether or not a remedy could be crafted that would allow those voters to be able to access the ballot box, voters who didn't have one of those forms of ID. But I think after the ruling in North Carolina, I think I'm increasingly skeptical that we'll see courts upholding even sort of milder forms of these photo ID laws that are intended to sort of create a fix. At the end of the day, what the court ruled in North Carolina is that that law had a discriminatory impact on African Americans in the state. And more than that, lawmakers knew that impact and they intended that impact. And that is a violation of the Voting Rights Act and the United States Constitution.
So there was documentation of that intent.
Absolutely, absolutely. In North Carolina, in fact, lawmakers requested data about the demographic and racial impact of the law before they passed it. Mm-hmm. And the court noted that that was fairly close to a smoking gun with respect to their intent. And that's what we see around the country. We know that these laws are not intended to uphold the integrity of the voting process because that argument has been debunked by social scientists across the country. It is now well recognized that voter impersonation is simply something that doesn't happen at the polls for a variety of reasons. And what we know is that these laws are targeted towards particular classes of voters, including voters of color, including senior citizens, young voters, voters with disability, low-income voters, people that are less likely to have a car or a driver's license. Not because they are more likely to engage in voter fraud, but because of their politics, because of how they vote. And what the courts are saying now in these series of rulings that have come down over the last several weeks is that that's not okay. You cannot target classes of voters, particularly voters of color, to make it harder for them to participate in the process solely for political gain. And that's exactly what's going on. And when voters understand that that's really what's happening, they will vote against Amendment 6.
What does Texas have to do to satisfy the Fifth Circuit as far as leaving?
Well, that's going to be for the lower courts to decide. There's the lower court is going to rehear that part of the case. They're also going to re-examine the question of discriminatory intent, whether the legislature there acted with discriminatory intent, and depending on how that part of the process goes, it could go back up to the Fifth Circuit Court of Appeals again for review.
And which is a conservative court.
It is. I mean, look, what we've seen now is that several major federal appellate courts in the South, the Fourth Circuit Court of Appeals, based in Virginia, ruled against a North Carolina law in the South. The Fifth Circuit Court of Appeals ruled against a Texas photo ID law. These are courts that are rejecting voter suppression laws in the South. And that's echoed by these court decisions in Wisconsin. In North Dakota, the court there found that the voter ID law shut out indigenous populations, Native American voters. And I think that it has become clear what voters of color and other voters who are affected by these laws across the country have long known, is that these laws are intended to do nothing but target certain classes of voters and make it harder for them to participate in the political process.
Okay, back to Missouri's process, the constitutional amendment. Is there no remedy then for that if voters were to approve the constitutional amendment enabling the legislature to enact the photo ID? What's the remedy? If indeed we find that, as you say, that it's keeping up to 220,000 people from their right to vote.
Right. Well, first of all, we're convinced that we're going to defeat Amendment 6 at the polls in November. When voters understand the impact of this law, they understand that democracy doesn't function if all who are eligible aren't allowed to have a voice. And voters in Missouri are wary of politicians manipulating the system for their own political gain. And so I feel confident that we're going to be able to defeat Amendment 6 come November. If it passes, that would open the door to the legislature to pass a restrictive photo ID law. And that law would no longer be in conflict with the Missouri Constitution, as it is now. But that doesn't mean that that law couldn't be subject to a federal constitutional challenge or a challenge under the Voting Rights Act.
So that's not necessarily the end of the road.
It might not be the end of the road, but I suspect that before that time, one of these other cases that's making their way through the federal court system around the country may get heard by the United States Supreme Court. Probably not before November, but probably sometime in the next term.
And the decision could impact the Missouri constitutional question.
It could. Depending on which question the court decides to take. And look, at the end of the day, what we are seeing here is the result of a really disastrous Supreme Court decision from a few years ago called Shelby versus Holder that ended up gutting a key provision of the Voting Rights Act that required states that had a history of discriminatory voting to pre-clear new voting practices. States like North Carolina, like Texas, Mississippi, Alabama, all these states that have now tried to implement photo ID laws. And that ruling opened the door to not only a slew of new restrictive voting practices around the country, but also this slew of litigation that now puts the burden on the backs of voters to challenge these discriminatory laws in court. And so there's still an open question that remains about whether or not the remaining provisions of the Voting Rights Act will step in to block discriminatory voting practices. There continue to be questions that come up with respect to the nature of the right to vote under the Constitution, and those questions have to be addressed ultimately by the Supreme Court. And so Congress could really nip a lot of this in the bud. In fact, if they reinstated preclearance provisions of the Voting Rights Act, there's legislation pending before Congress right now, and they've let it sit. They're on recess right now.
Yeah.
And we could go a long way to addressing some of these issues if we thought seriously about what it means to have an affirmative right to vote in this country. One of the reasons these court cases are taking up so much bandwidth and so much taxpayer dollars is our Constitution doesn't include an affirmative protection for the right to vote. There are numerous provisions in our Constitution that discuss that we can't abridge the right to vote on account of race and gender and age, but nothing that affirmatively elevates the right to vote as a fundamental right that would require states to have to present a very, very compelling justification before they restricted voting. And that's the direction that we need to take in this country. We should be making voting more accessible, not less. This is the first period in American history outside of the post-Reconstruction era where we are seeing more efforts to restrict access to voting than to open access.
What's the origin of this movement to photo IDs, restricted voting?
Well, you know, I think that we can trace this to the 2008 election of Barack Obama that brought out record numbers of voters of color, record numbers of young voters, record numbers of women. It's a group that we call the Rising American Electorate. And as we see the increasing political power of voters of color, of young voters, of women, and we look at the demographic shifts in this country and where that's going, well, we see that the demographics of the electorate are changing, and that these communities, the communities that are directly affected by these photo ID laws, are now in a position or stand to be in a position very soon where they can claim some political power that that in fact should be rightly theirs, that has been denied them for very long. And so it's no surprise then that people who are clinging onto power would want to resist that.
Yeah, and I can see how the 2008 elections would energize that movement, but clearly the movement preceded that. As you know, 2005 was the first attempt to do that in Missouri. And I don't know whether was Missouri the first state that attempted to do photo ID?
Well, Missouri was one among a small handful. Missouri,
Yeah.
Georgia, and Indiana were early onboarders of photo ID. And some of this discussion came out of actually the 2000 presidential elections. There was a bipartisan commission on election reform where discussion about identification issues arose as part of that. But as one of the dissenters to that report points out, it really was never intended to sort of go this direction of a strict photo ID law. And even now, what we see is that folks that were early supporters of these sorts of laws, even conservatives, one of the most conservative judges in the country, who originally upheld Indiana's photo ID law, has since issued publications saying, you know, there's a lot we didn't know then about the ways that these laws cut people out. There's a lot we didn't know then about the discriminatory effects of these laws. And there was a lot we didn't know then about the very, very low incidence of voter impersonation. So
you can reassure Missourians that their electoral process is secure.
You don't need me to reassure Missourians. Like I said, both Republican and Democratic secretaries of state, our state's top elections officials, have frequently pointed to the fraud-free nature of Missouri's elections. And the fact is that there are numerous processes in place. And I'm not saying that there aren't problems with our elections, and many voter advocates, like the League of Women Voters, regularly meet with elections officials and advocate for reforms to voting. But that one activity, going to the polls and pretending to be somebody else, just simply doesn't happen. There have been studies around the country on the incidence of voter impersonation. They're exceedingly rare. In North Carolina, in the litigation, the State Board of Elections produced a report covering like 14 years of elections, and only 2 cases were even referred for prosecution, never even came to prosecution. Our state's elections officials here in Missouri have a vigorous vetting process for any allegations of voting irregularities, and error on the side of referring cases for further review for prosecution if there's any evidence whatsoever. Pretending to be somebody else at the polls is just something that doesn't happen, particularly in a state like Missouri where you have to present some form of identification already.
Right. Yep. Well, guess what? We're running out of time. You make a very compelling case that this would be the wrong way to go. And any last words for Missourians?
Yeah, you know, I think that it's really important to step back and think about why voting matters and why we care about the right to vote. The right to vote is the one institution in our society where the playing field is level, where we are all equal, where the vote of the rich man counts the exact same as the vote of the poor man. The vote of the PhD counts the same as the vote of the GED, right? And it is the real equalizer, the only equalizer in our society. And the democracy cannot function if those who are in power manipulate that system for their own political will in order to cut people out of that process. The right to vote is the foundation of our democracy, and we should be working to ensure that it's accessible to all eligible voters in Missouri.
Well, with that, we need to say good night. Thank you, Denise Lieberman.
Thank you for having me.
And thank you for joining us. Until next time, good night.